Welcome back, everybody, to the Law of Contracts. We're continuing talking about the idea of consideration in this video, asking the question of what constitutes sufficient consideration, and what the difference is between adequate and sufficient consideration for the purposes of establishing a contractual arrangement. So really, what steps do we have to go to? We will discuss the comparison and the meaning of the comparison between the idea of sufficient consideration on the one hand and adequate consideration on the other, what these things actually fundamentally mean, and whether or not these things have a meaningful difference when we actually start to talk about the law itself. So, the general rule for the courts is that consideration at issue in the contract be sufficient to render the promise enforceable. It's as simple as that. In order for there to be consideration that renders a promise enforceable, that consideration has to be sufficient. There has to be a certain sufficiency established in it. And this is as a result of which means that the role of adequacy is not present in any kind of understanding of consideration. This does not place adequacy requirement on the issue of consideration. So, in fact, so long as the promise is enforceable, the consideration will be valid. And this is even the case if the courts or even the general public may suggest that the consideration did not represent a fair deal. So one of the things that should be noted is that consideration is, of course, something for something else, is an exchange of promises, but those promises don't need to be equal on either side. It doesn't have to be the case that the deal is fair. We could all come to the conclusion that, in fact, it's not a fair deal at all, that this person has been swindled by the other person. But whereas that might represent something of an injustice in terms of being able to establish a fair deal, it doesn't make anything or speak anything to the question of whether or not there was consideration, and whether or not, as a result of which, the promise is therefore enforceable. There is nothing unlawful about making a contract which represents an unfair bargain. You could theoretically sell a car for a £10 note. That's not necessarily suggesting that the deal is fair, because of course the value of a car is much higher than that of a £10, but it still represents something of a consideration. An illustration of this is the 1842 case of Thomas and Thomas. In this case, the issue of sufficient consideration and then the central question of whether or not the promise was enforceable came to head in the dispute. At the death of a husband, it was made clear that he wanted his wife to be able to freely live and stay in the house that they had owned. However, this was not something that was clearly stated in the will, so the executors of the will suggested that she be allowed to stay if she paid rent of £1 per year. Okay, not much money for even 1800 standards, definitely not much money in terms of today's standard. If you can get rent for £1 a year, then you are in a really good deal. When it was attempted to dispossess her, the question of whether or not this amounted to consideration and therefore was enforceable was a question that came to the court, because it seemed to be the case that it was so unbelievably unbalanced that the rent that she would pay is £1 a year, that it meant that surely this can't represent consideration for the enforceability of a contract. Well, the courts held that the wish of the husband in and of itself would not have been sufficient to amount to consideration. So just having the death of the husband and making it clear he wanted his wife to be able to live there, that wasn't enough in and of itself to amount to a sufficient amount of consideration. However, even though it wasn't an adequate amount of consideration, given the fact that it was an unfair deal, given that she was only paying £1 a year for rent, the payment of £1 a year was nevertheless sufficient to enforce the contract, because it was sufficient consideration. And so the question of consideration, generally speaking, is that it will have to represent some kind of tangible piece of real value. It has to have some kind of value attached to it. But the amount of value doesn't seem to be something that is much of an issue here. Like I said, you could buy a car for a £10, and even though it doesn't seem to be a fair deal, it is still real value. £10 it still has value in the world. It just doesn't have enough value to be an equally fair deal given the market prices of cars today. Similarly, £1 a year in rent, again, isn't a fair deal, but it is still real value. A pound is still something of real value. It's tangible, okay? The amount of value relates to the adequacy of the consideration. And so really the question of how much value we are adding or how much value we are giving in terms of consideration is a question of adequacy, which, as we've noted, is not relevant for the purposes of just establishing a consideration. If I were to contract with you and to purchase a very expensive diamond ring, and we were to agree to an asking price of £1.50, this would definitely not be adequate consideration. It would not represent the true worth of the product. It could be thousands in reality. But if it was agreed by the parties, it will be sufficient. And given the fact that £1.50, despite not being very much value, is still a tangible piece of value, it would suggest that therefore it was enough for sufficient consideration. Another example of this case is in the specific case of Chappell & Co. versus Nestle from 1960. It was another case which represented this idea of so-called nominal consideration. The claimants in this case had been the defendants, had been the owners of the copyright of a song. The song was called Rockin' Shoes, okay? The defendants sought to use this copyright with their permission and so offered to purchase it for 1 shilling and 6 dimes and 3 chocolate bar wrappers, okay? A very nominal amount of consideration, a very what would seemingly be a very inadequate amount of consideration. Because the record itself, even though it was purchased for the price of 1 shilling and 6 dimes and 3 chocolate bar wrappers, the record itself would sell at a price of 6 shillings and 8 dimes, so quite significantly more than what was originally bought for. The question for us was whether or not the 3 chocolate bar wrappers would represent sufficient consideration, despite the fact that they had no value to the claimants and had been thrown away immediately. Okay, obviously we know that it wouldn't have been adequate consideration, it wouldn't have represented a fair deal, but was it sufficient to even establish the existence of consideration? It was held by the courts that they were, and they said the following. They said that it is said that when received, the wrappers are of no value to Nestle. This is irrelevant. A contracting party can stipulate for what consideration he chooses. A peppercorn does not cease to be good consideration if it is established that the promisee does not like pepper and will throw it away. Okay? This is a very important point, because it suggests here that the tangibility of value in relation to consideration being sufficient is something that is not subjective. Okay, just because to Nestle 3 chocolate bar wrappers has no value to them does not mean that it doesn't objectively have no value tangibly whatsoever. And so the question of whether or not they had value to Nestle was an irrelevant point of fact. And the analogy used of peppercorns being thrown away because the promisee doesn't like pepper does not mean, therefore, that pepper has objectively got no value or peppercorns have no value. And so the result of this is that anything that is tangible in terms of value can represent consideration. And even if, like it says here, they had no value to the particular person in question, is irrelevant. And what is interesting here is that a contracting party could stipulate for what consideration he chooses. So if they suggest upon the creation of a contract that they want a specific type of consideration, a specific amount of consideration, then this would be considered as part of the establishment of sufficient consideration for the purposes of a dispute.